Hello, Stephanie Joy with All Things Social Security. We had a Q&A with a short little clip discussion on a particular topic. So I'm going to attach it for you here. It might be something that you're interested in if you clicked on this header. And following that, we're going to go through it a little bit more. So just wanted to give you the heads up. This is where it started from, and then we'll have the bigger discussion right after. All right, chat with you later. Bye-bye. Angie pops one in. Is more hypotheticals better than less hypotheticals? Oh my gosh, that is such a good question. If there's one question and there's no jobs, that, Angie, is probably the best situation. There's going to be no jobs with the hypothetical as laid out by the judge, not the supplement ones and he adds in off task and all that. I had a judge once who did 7 hypotheticals and then denied my guy. I didn't expect it. We did appeals counsel appeal and we did get it completely reversed, not just a remand. But that was because the facts that the judge found at that point now would have him grid out without changing any of the findings of the judge, because the grids are the law. They're not, you would have thought the judge maybe would have applied them since he was close to that age at the time, but he didn't. And maybe he couldn't. I mean, I don't really follow the strictures of when they can, should, would until I have to. But that was 7 hypotheticals and a denial. But I've seen many hypotheticals and an award. So I just like to see 1 hypothetical with no jobs. So it's almost wrapped up in a bow. Anyway. All right, guys. I hope that's it. I hope you have a great week. Everyone be safe. Take care of your cases. Treat. If you have an open claim or if you're soon to have one. And if you've already prevailed, always remember that you have a CDR coming up. So don't forget to keep at least that minimal reasonable treatment with all those different body parts in order and current. Andy had 3 hypotheticals and 2 had no jobs and 1 had a job. So was it like light? First one, light exertion. There was a job. Second one was same RFC VE, but let's just say the person's limited to sedentary. And did the VE say no job for that? And then did the third one go, let's go back to the first one. Let's say it is back to light VE. But let's say in addition to the first criteria, the person would also be off task 20% of the day. Would there be any jobs? No jobs. So that would be 1 with jobs, 2nd with no jobs, 3rd with no jobs. You just don't know the answer. Where's the judge going to go? You almost like to think, well, because he kept asking and getting more and more, that would be no jobs. Why did you do that again? But you, in my opinion, can't quantify it that way. It would be nice, but no, it's excruciating. All right, guys, I'm gonna get out of here. It is starting to roast in here. Good morning. How are you all? Hope you're doing well. Wanted to share, today was big hearing day. And we had a video not that long ago, I don't think, about the ways in which an ALJ might pose questions to a vocational expert. And I think the last one we did was when there was 1 hypothetical and the general take on that, depending on the results of that 1 hypothetical. So at this hearing yesterday, it was pretty interesting. I never saw it done like this before, but it seemed to go pretty well. It wasn't 1 hypothetical either. So I just want to run through it with you because you might find that this happens. So in this particular case, the past relevant work is really important because that has to do with the grids and an older individual. So let's say the job that the vocational expert categorizes the claimant's past work as was an insurance clerk. This is the kind of job that so many of you have had out there. It's usually, I guess, oftentimes in a medical provider office, and you're making sure you're part of the team or departments that make sure that the insurance companies pay the covered treatments, say, the visits, all that kind of stuff. And I think they delve into it when the insurance company denies something or only pays part, etc. Those explanation of benefits and what have you. So anyway, in this particular case, insurance clerk, and I'm going to give you the DOT number. That's the Dictionary of Occupational Titles. And this particular code number, if you wanted to look it up, is 214-362-022. And that was the only, that the person had worked for the same company under different names for a couple decades. So that was the only past relevant work.
We are still technically under the 15-year standard. As you know from prior videos and elsewhere, you've probably seen out there, we're changing to a 5-year look back period, which is super. But for now, that doesn't count. And it wouldn't make a difference in this particular person's case because the same job the last 5 years as, before. It's SVP 5. That means a skilled job. It's not as skilled as, say, an 8, which might be, say, a rocket scientist, but it's still a skilled job versus a unskilled job. It is sedentary as normally performed in the economy. Now, in this particular instance, I did argue and show through work history description that as performed, it was light work because it was too much time on the feet to be falling into the sedentary category. But as a general rule under the DOT, they define it as sedentary because most of the time you're on your feet for less than 2 hours of the 8-hour day, and you're on your duff for 6 hours. So when the vocational expert testified that that was the past relevant work, the judge immediately asked some questions about the SVP 5. And she says, does that mean it's detailed work, precise, et cetera, et cetera? And the VE said, yes, it's very detailed, very precise, dot your I's, cross your T's. This is insurance documentation. It's super precise. And that was a good answer because a large part of our proofs and what I'm arguing is that it is too mentally arduous for my client to do today. In a nutshell, I could say there's severe fatigue problems. I would say for all of you long COVID people, as a separate note, if you suffer severe fatigue unlike you've ever had before, and it's post-COVID, long haul, whatever you want to call it, that is a really, really important area to specifically get medical evidence of an ongoing nature on. I mean, whether you go to a fatigue specialist, maybe you have doctor appointments just because of the horrendous fatigue, whatever it is, you want to work that up. It can be a major, that's such a subjective thing because there's no markers for it and they have to take your word for it some of the time. But the more you complain about it, the more you get treated for it specifically. Treat it as the really severe limitation it is and that you're trying to remedy it. So there are chronic fatigue specialists out there. They're few and far between, I would say, and a lot of doctors are not really fatigue literate, but it's something you're going to want to pursue. And that we have a lot of that here. So the judge asking about that, and she's just asking about the categorized work. So would that job be really required detail and precision? I knew this was in our favor, this section. Doesn't mean you hang your hat on it, but it was a good sign. She also asked about, does that require frequent talking? And on our work history report, we had put in, it was literally constant typing and constant phone conversations with the insurance carriers all day long. So pretty much every hour you're in your seat, you're on the phone and or typing or both at the same time. So because there is a fatigue and a breathing issue, talking for frequently, by the way, when they say frequent talking is required for this job, that means anywhere from 1/3 of the day to 2/3 of the day. When you look at that, you know how occasionally is 0 to 1/3 of a day. That means occasionally can be up to 2.5 hours a day, which I think is pretty significant, but that's considered occasional. Frequent is 1/3 to 2/3. So in a nutshell, just think of it as, is it generally around half the day, give or take? Then maybe it's frequent. And if it's more than 2/3 of the day, it's on a constant level. So that's almost like always or almost always throughout the day. You're doing it the entire time. I just pressed a button by accident. Okay, so when the judge, smartly, I would say, asked the VE about how much talking is required that job, frequent talking is required for that past relevant work, I was like, yes, 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 yes. Ding, 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 ding. Things are looking good. So that was an interesting part before she got into her hypotheticals, this was. And the hypotheticals were almost twisted around backwards because there's many ways to skin the cat, right? So instead of going through a whole big list of limitations and the exertional limitation of, say, sedentary, she didn't even bother with that. Hypothetical 1, she basically says to the VE, Mr. VE, if the hypothetical person cannot do frequent talking, would they be able to do that past relevant work? Well, we all know the answer is no, and the vocational expert said no. And past relevant work was very critical. I think I mentioned this before. This is an older individual. You have to prove for everybody they can't do their past relevant work, but for the older individuals for whom a grid, a MedVoc rule might apply, you get through the no past relevant work and no transferable skills. And then you get the blessings of the grid if your shoe otherwise fits. So that was really important. Hypothetical 2, no long gamut there either. She said, if the hypothetical person is limited to 2 or 3 step tasks, can't do chores, work projects, or whatever that entail more than 2 or 3 steps due to that concentration issue, what have you, would that person be able to do the past relevant work? No. Hypothetical 3, if the person is limited to sedentary only, can't do light work, and if they would be unable 1 to 2 times a week, no, 1 time a week, it says, I'm looking at my notes, so bear with me, 1 time a week, consistently 1 time a week being unable to do even the 2 to 3 steps, would there be, she asked about past relevant work. I'm going to have to go take a re-listen, but we already knew that if they even could do the 2 to 3 steps, they couldn't do the past relevant work. But anyway, I think she's covering her bases here. No past relevant work. And then if the person was going to, this is number 4. These are the most bizarre standalone hypotheticals in my experience, but good. If the person would be absent 2 to 3 days a month due to medical problems, would there be any jobs that could be done? And the answer was no. And we know that because while the DOT might not address this specifically, think about it. And I think the VE said it here. Most employers, she said, give people, I remember she used the number 6, but she gave a range. It might have been 6 to 8, 6 to 8 days. I assume she means between personal and sick and all that. Total, and I think she meant for the year. And she said, and if they're taking 2 to 3 days a month, they're never going to make it to a sustained basis, which is 6 months generally, because they will have exceeded their days within just a few months and never hit the 6-month mark, and they would be fired. So that's true of like most all jobs when you start. If you start having that high end of absenteeism, it's going to get you fired pretty quick, generally speaking. Now, it's funny, as an aside, in the economy we're in now and how so many people don't work, employers are really taking it up the Yahoo in tolerating bad work morale, work ethics, I think, from many employees, particularly our younger crowd. No offense, young people, but it is what it is. I see it all the time. Every time I go out, I'll hear like, oh, so-and-so didn't show up. So-and-so showed up 3 hours late. Back in my day, and I know I'm an old dog, you'd be so out on your butt. You know, they're paying higher wages than ever before, you know, double minimum wage, and for unskilled starters, and people just don't show up. It's incredible to me. So, anyway, those hypotheticals were so bizarre. That's not how we normally hear them, but they all answered in the best way they could. So I left them alone. It wasn't about to open a can of worms. It appeared to me similar to when a judge asks for one hypothetical and there's no jobs available under that hypothetical. Even if there's 4, if no jobs have been suggested, not a single job has been suggested, including past relevant work, but no others either. I think she was creating the case for awarding my client. Didn't give us the award in front of us, and we still actually have a few more medicals to submit that just occurred. And I was kind of disappointed that there wasn't just I don't think I'll need those, counsel, so you'll get my decision, you know, the hearing is closed. She didn't do that, which was interesting. So I always say we can't say for sure what's going to happen because there can always be a wild card. You can have a judge who has a brain fart, who knows? But we have a good cover if there was a brain fart for an appeal. And that's the job, to make sure you have that. So anyway, interesting hypotheticals from the judge. I like them. I think she's definitely on the claimant side, but you can never say sure, for sure, because weird things have happened. Very rarely, but they've happened a few times in my experience. Okay, chat with you later. Have a great day, guys.